Okay, so in the last podcast, we talked about some of the legislative changes that are affecting how we present medical bills. And I told you in that segment that one of the easiest parts is proving the bills because the bills are there. There, you can read them, you can calculate them, and we showed you a board. So on this segment, we're going to simulate a brief closing argument. And so we had this accident that we talked about from August 15, 2015, okay? And some details about the accident. This is kind of what we would be presenting to a jury so that they can make a decision. So we have this August 18, 2015 accident in Ocala. We're talking about how the accident happened. The client was in the rightmost left turn lane heading towards another street called North Pine. She stopped for a red light, and then she's rear-ended toward the right rear of her suburban vehicle by what we'll call the at-fault driver, who was driving a white Chrysler Town and Country van. And here's some of the photos. We would show the jury, hey, this is the damage. Okay, these are the damage to the vehicle. So you got this, that's my client's vehicle because it was a rear-end collision. And then that's the other vehicle. So that's the extent of the damage. How much injuries can you sustain from the given amount of damage? That's what the evidence is for. So keep in mind, by this point in the case, you've already heard 3 or 4 days worth of testimony substantiating why someone was injured from that type of accident. So skipping over to jury instructions. This is what the jury is told they have to do. Does a jury follow it all the time? I don't know. They're supposed to. The judge will read these over and over again throughout the case. And a lot of times in closing argument, a good lawyer will present those closing argument, the jury instructions. Okay, so in this case, one of the questions is legal cause. Well, what does that mean? Negligence is a legal cause of loss, injury, or damage if it directly in a natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage so that it can reasonably be said that but for the negligence, the loss, injury, or damage would not have occurred. That's what we have to prove as plaintiff's lawyers. We have to prove that not just the person's injured because of something that happened, like an auto accident. This is very important. Aggravation or activation of disease or defect. People come through all walks of life. A lot of people have been injured before. In this case, as you may recall, this was a neck injury where someone required surgery. So in this case, there was evidence in the case that this client had neck injury sustained prior to the accident. So the jury instruction says that if you find that the at-fault driver, through his or her own negligence, caused a bodily injury, and that the injury resulted in an aggravation of an existing physical defect or activation of a latent physical defect, you should attempt to decide what portion of our injured client's condition resulted from the aggravation. Not from what was before, but what was from after the accident. If you can make that determination, then you should award only those damages resulting from the aggravation. However, if you cannot make that determination, or if it cannot be said that the condition would have existed apart from the injury, then you're implored or you're ordered through the instruction to award damages for the entire condition suffered by the client. Again, all of it is dependent on the evidence throughout the 3-4 day trial. This is the burden of proof in a civil case. The greater weight of the evidence, 5149 is the way I call it. It's not beyond a reasonable doubt. The greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. So looking at everything that's been presented over those 3 or 4 days, did the plaintiff prove their case by the greater weight of the evidence? You hear a lot in trials about possible versus probable. Is it more likely than not that our injured client's neck and back were injured in the August 18, 2015 accident? That's what the jury has to decide. Medical bills. This is going back to that original podcast. This is the first element of the personal injury case. And you remember this number, $181,798.45. If you look at our first podcast, this is the number that before the legislation we were allowed to present, and we told you why. You get a verdict form at the end that allows you to decide the elements of damages and how much or how little, right? The first question, and it's kind of small there, but it's what is the total amount of our injured client's damages for medical expenses incurred in the past, which were caused by the accident on August 18, 2015. The past meaning the date of today, the verdict, the date of the verdict through the date of the accident, going backwards. That's the easiest part. That's the part that goes back to our board. in this case, what are we going to ask the jury to award? Well, we're going to ask them to award the bills. We're going to ask them to award the bills, because if you listen to the last podcast, you'll know that there's going to be reductions made on that. But we want these bills entered in as her damages because they all relate to the accident. So the verdict form then says, well, let's go to question number 2. And we're talking now about permanency, okay? An injury is permanent if it in whole or in part consists of an injury that the evidence shows is permanent to a reasonable degree of medical certainty. And that's where the doctors and the experts come in on both sides and talk about whether she has a permanent injury, the client. Our injured client surgeon in this case, and we're protecting names, to protect the innocent, we're not revealing names. Our injured client's neck injuries are permanent, according to the treating surgeon in this case. She had 3 scars from the neck surgery. So if you can prove permanency, that's where you get to pain and suffering, which will go at the end here. But the second question then says, did our injured client sustain a permanent injury as a result of that accident? And we're going to say yes, because there's a surgeon that operated on her that says she does. Now, the defense will be allowed to provide evidence to contradict that. And given that she had a prior injury, that could be an issue in this case. If your answer to number 2 is yes, please answer question 3, which is what we'll talk about here at the end. Pain and suffering. What is that? There is no standard. But here's what the law allows you to recover. Pain and suffering, disability, physical impairment, disfigurement, mental anguish, inconvenience, loss of capacity for the enjoyment of life in the past and in the future. All of these elements in the past and in the future. How do you put a value on that? Well, this is what the law instructs you to say. If you find that an injury is permanent, remember that's a prerequisite, then you shall consider damages for any bodily injury sustained by our client and any resulting pain and suffering, disability, physical impairment, all those things, disfigurement, mental anguish, inconvenience, or loss of the capacity for the enjoyment of life experienced in the past or to be experienced in the future. Look at the next sentence. There is no exact standard for measuring such damages. The amount should be fair and just in light of the evidence. And here's where the jury really comes in. This is the testimony in a brief. Again, you didn't have the benefit of being here for 3 to 4 days, but in this case, this client who had neck pain had a kink in her neck 2 to 3 times per week, which occasionally travels down her arm. Okay, on a good day, she reported a 3 or 4 pain level out of 10. On a bad day, 8 to 9. She was better than before the surgery, but still there. This is after she had the surgery. She reported a vice grip pain in the middle of her lower back every other week. That's regarding her back. And she also reported some pain levels. So the jury has to hear all these evidence. And current pain means this is pain after her surgery. What has it done for her in the future? Well, we talk about limitations in performing daily activities. And keep in mind, the client is going to be on the stand testifying about this, usually on the second day of the trial. She's going to testify what activities, daily activities on a personal level, on an occupational level, on a household level. She mentioned in this case, household chores, doing things that sometimes we take for granted, bending, walking, and sitting for long periods of time, reading, fishing, kayaking, theme parks, cooking, going to parties, socializing, things that she feels pain sometimes. She's not saying she can't do these things. She's saying she's limited when she performs them because of the injuries. She mentioned that it affected her relationship with her children, sports games, playing with her youngest child, playing catch. She did not have these limitations before the accident. That's the testimony she provided. And this is what we would say in our closing argument. So then what you do is you look at her life expectancy. Well, our example client here was in the 40 to 41 range, and she's a female. This is the mortality tables, okay, that are accepted into these cases. And if you scroll all the way to the end, you'll see her life expectancy as a female in the 40 to 41 range at the time of this trial is 42.6 years. So how do we use that? Well, you use that to determine how much longer she's going to have the pain levels. If she's going to have, for instance, future medical bills as a part of her case, we need to find out how much longer she's going to have. And one of the barometers is, what's your life expectancy? So the last question on the verdict form is, what is the total amount of our injured client's damages for this pain and suffering, all these other elements, as a result of the accident on August 18, 2015? You got to answer it for the past, and you got to answer it for the future. And remember, she has to sustain a permanent injury before you get to this question. So think of all those things. If you're ever called upon as a juror, think about where you're at, and these are the elements you have to decide. But again, there's no exact standard. So here's where we always hear things about, well, it was a runaway jury or a huge verdict. And a lot of times it's these damages. Okay, but remember, it's a jury of our peers that is deciding these damages, not the lawyers, not the judge. So the verdict form, at the end, what are plaintiff's total damages arising from the accident? And that's where we leave it here. We leave it here with you guys because we know for sure that the damages we're presenting are that $181,000 figure. But what are the damages for pain and suffering? These are elements of damages that you should consider in a trial. If you have specific questions, this is a very abbreviated closing statement or closing argument. Give me a call and we'll talk about it in further detail.